Delivering this week's must-watch workplace storylines, this is Bloomberg Law's Punching In for those of you listening in Washington and across the globe.
Hey folks, welcome, and thanks for punching in with us here on our inaugural episode. My name is Hassan Kanu. I'm a legal reporter here on the Labor and Employment Desk at Bloomberg Law. As a personal note, my particular focus is the Federal Labor Board, known as the National Labor Relations Board, or NLRB, although, of course, I report on and will be keeping you up on all the news in the labor and employment space in the coming week. We'll be giving you a brief rundown and look ahead of everything that's going to happen and may or may not happen that you might want to keep an eye on. So we hope you punch in with us weekly for that nice brief rundown. Chris Opfer will be joining us for our next story. The Restaurant Law Center, that's the legal arm of the quite politically influential National Restaurant Association, also known as the other NRA. They're suing the DOL over something called the 80-20 rule. So first off, Chris, can you explain that rule to us? What does it actually mean? How does it apply?
Right. The rule impacts tipped workers like bartenders and servers in restaurants. Those workers, by and large, make a lower tipped minimum wage at $2.13 an hour as opposed to the general minimum wage of $7.25 an hour, with the idea being that tips will fill in the gap. The question came up during the Obama administration about what to do when workers in those industries are doing tasks that don't generate tips, so things like side work, folding napkins and cutlery, doing food prep, things like that. The Obama Labor Department said if a worker spends 20% or more of his or her time per week on those non-tip tasks, then he or she has to get the full minimum wage.
Okay, and what is the NRA's interest here? What's their angle in the lawsuit?
So the lawsuit is about rulemaking procedure largely, and whether or not DOL jumped through the necessary hoops to roll this out. But the NRA's interest really is about defending lawsuits. We've seen some pretty big litigation on this rule with workers demanding to get back wages, particularly against Buffalo Wild Wings.
All right, and is it a bit early to read the tea leaves here, or how do you expect this to play out?
We're keeping an eye on September 10th. That's the deadline for the Labor Department to respond to the lawsuit. We don't know one way or the other how they're going to come down on this. We know that Secretary Acosta is a very thoughtful, deliberative guy who's going to weigh both sides of the argument. And it'll be interesting to see how this plays out, particularly because the restaurant groups have been on sort of had some friction with the DOL over a separate tip pool rule. And this could be potentially a way for them to smooth things over.
All right. We'll definitely be keeping an eye on that in September. Thanks for joining us, Chris.
All right, thanks.
So as it turns out, Steve Bannon, former chief strategist, of course, in President Donald Trump's White House, was apparently the barrier preventing the Department of Labor from changing how it enforces a wages and pay rule related to federal construction here in D.C. and other public works generally. That law, of course, is known as the Davis-Bacon Act. That's been around for decades. And basically, it requires contractors and subcontractors of the federal government to pay their workers, laborers, mechanics, other positions, what's known as the prevailing wages for similar projects in the region. Essentially, if you have a government contract, you sort of have to pay folks something comparable or essentially equal to what other people are paying for similar work in that region. Of course, there are some private sector contractors and subcontractors who'd prefer to determine those issues independently and on their own. Republicans tend to favor policies that allow more freedom for capital, entrepreneurs, big business. But according to a former senior administration official, it was actually Steve Bannon who apparently blocked attempts to change the way the law is regulated. That was essentially because Mr. Bannon felt like sort of tweaking with construction worker pay could possibly expose President Donald Trump to criticism, given his own working class base there. Bannon is gone now, of course, and a lot of folks are speculating, and some sources are telling us that likely opens up a pathway for the White House and Department of Labor to start working together on possibly tweaking the way the law is enforced. And we hear that that's aimed essentially at facilitating more construction projects under the larger banner of the White House Infrastructure Initiative. Now we are going to Missouri for our second story. Voters in Missouri are going to the polls to vote on a referendum that would make the state a right-to-work state. Much of the South is already, of course, right to work. What that means is that they have policies that ban what's known as agency fees. Agency fees are payments required of people who work in the government, whether federal or state. They're required to pay a smaller fee than the actual union members in their workplace, and that's supposed to cover the union's costs in bargaining for their employment contract. That's because the employment contract necessarily by law covers everyone in the bargaining unit, not just members. So voters in Missouri will be deciding whether or not to keep allowing under Missouri law those agency fees, which are also otherwise known as fair share fees in the sense of pay your fair share. This is not the first time this referendum or measure, in the past it's mostly been legislation, has come up, but it's failed multiple times in the past, over 20 times. This is the first time, though, that the referendum has actually been moved up from the general elections in November to the primary elections. Democrats in the state, Republicans spearheaded this referendum, or at least a measure. Democrats in the state have criticized the Republicans' decision to move the referendum election from the general to the primary, making the point that there's lowered voter turnout in this election as opposed to the one that would happen in November. So we are yet to see how that vote might shake out. Lots of folks are speculating that the ultimate result might affect how people feel about what the current law changes to and subsequently how they might decide to vote in November. So keep an eye on that. Looks to shake out and have long-lasting effects. All right, that is it for this week. Thanks for joining us again on our inaugural episode. Be sure to punch in with us again next week to hear a rundown of what's happening in the labor and employment space. Have a good one.